Where any part of a will is ambiguous or meaningless, such that it's not possible to establish a person's true intentions, then a person can apply to court for what's called construction. Construction of wills is essentially concerned with establishing a person's true intentions. The law on construction has developed and evolved through case law and statute, specifically Section 21 of the Administration of Justice Act 1982. When construing a will, the court has to put itself in the mind of the person who made the will and interpret the words used in the light of all the relevant facts and circumstances. The Supreme Court decision of Marley and Rawlings gave a really good, useful summary of the law on the construction of wills. In that case, the Supreme Court confirmed that a will should be interpreted in the same way as a contract. For example, by identifying the meaning of the relevant words in the light of the natural and ordinary meaning of those words, the overall purpose of the document, any other provisions of the document, the facts known or assumed by the parties at the time that the document was executed, and common sense, but ignoring subjective evidence of any party's intentions. However, the Supreme Court confirmed that where any part of a will is ambiguous or meaningless, the court can consider evidence of the person's actual intentions, for example, by reference to what they told the person who prepared the will or another person, by what was in any notes that they made or any earlier drafts of a will. Although it also dealt with construction, Marley and Rawlings was actually a case involving rectification of a will. Rectification, which is covered by Section 20 of the Administration of Justice Act 1982, allows a will, as the name suggests, to be rectified where there's either been a clerical error or a failure to understand the person's instructions. As such, it usually sought where a will writers failed in some way. In Marley and Rawlings, the error which actually led to the court application was because the solicitor had made wills for a married couple and he'd handed the wife her husband's will to sign and the husband the wife's will to sign, and therefore they needed to make an application to rectify those wills.